With it on behalf of Ms. Crittenden. Ms. Crittenden, can you please state your name for the record?
Savannah Crittenden.
You're requesting an adjournment. You were just recently appointed.
Yes, Your Honor. I was just appointed yesterday, so I don't have discovery yet on this matter. However, when appropriate, I would like to address bond.
Adjourn the matter July 31st, 2025, 9 a.m. Yes, that's the bond briefing.
Right away, this hearing comes in hot because the defense is trying to slow things down while also pushing for bond relief almost immediately after appointment. That is always a difficult balancing act. Savannah Kitten's attorney is basically telling the court, I just got this case. I don't even have discovery yet, but I still want the judge to consider release conditions. And you can already feel the tension building because the prosecution is clearly preparing to argue danger, repeated contact, and escalation. What makes this interesting is the framing from both sides. The defense paints this as proximity to circumstance, an extended stay hotel, accidental overlap, construction issues, no reason for contact. But prosecutors are preparing a completely different narrative, repeated warnings ignored. And in courtroom logic, judges care a lot about whether someone followed instructions after law enforcement intervention. Judge Simpson immediately sounds cautious here. He's listening carefully, but the tone suggests he's not eager to gamble on bond reductions when allegations involve stalking and a minor. And viewers, pay attention to this pattern throughout the hearing. Whenever the court hears Paulus had to come back again, that instantly changes how risk gets evaluated. Would you trust somebody to follow conditions after multiple warnings from police? That question is about to become the center of this entire exchange.
Your Honor, it's my understanding that these alleged incidents allegedly took place at an extended stay hotel while Ms. Crittenden's apartment complex was under construction. She has before staying in that extended stay hotel, had not known, and I would argue still does not know, the alleged complaining witness in this case, has no reason to have contact with them. I'm still trying to determine whether the construction at her apartment complex is complete. But Your Honor, I think that given the circumstances, I'd be asking for a release on a PR bond with a DPS tether with potentially a no-go to that extended stay hotel.
Response.
Your Honor, we would ask that the bond continue as set until the next probable cause conference date. The defendant was under investigation for criminal sexual conduct with a minor. That investigation was furthered for other information to be obtained. Ms. Crittenden was advised not to have any contact with the minor or his father, although there was no bond condition. She immediately went back to the hotel, had contact with the minor and his father. The police had to be called. The police came out, instructed her not to have contact with the minor and his father. The police left the hotel and were dispatched back again. She was in contact with the minor and the father and making hence the stalking charges. So we would ask that the bond continue.
And Your Honor, if I may,
yes.
Again, I just want to make sure it's clear. The CSC allegations, it's the same complaining witness as in the stalking charge. And again,
I get that.
So
this is one of those moments where the defense is trying to carefully acknowledge the court's concerns without fully surrendering the argument. You can hear the attorney attempting to soften the situation by clarifying that the CSC allegations and the stalking allegations involve the same complaining witness. Strategically, that matters because the defense wants this framed as one ongoing dispute rather than multiple unrelated dangerous incidents. But then the prosecution's narrative keeps crashing back in. The judge hears, warned not to make contact, police called twice, allegations of threats afterward. That combination is brutal for bond arguments. Judges look at behavior after warnings as a direct test of compliance. If someone allegedly ignores instructions immediately, the court starts worrying that future bond conditions may not work either. And Judge Simpson practically says the quiet part out loud when he admits he's surprised the bond is already this low. That is devastating for the defense position because once a judge says that on record, the odds of reduction drop dramatically. At that point, the hearing shifts from can conditions work to why should the court trust this defendant at all? This is why bond hearings move fast but carry huge consequences. A few minutes of allegations can completely reshape how a defendant is viewed before trial even begins.
I just want to make sure that was clear, Your Honor. And again, I don't believe she has any reason to have contact with them. And I think a GPS tether with a no-go.
But as I understand, she was told she was under investigation for a CSC, told not to have any contact with this specific individual as well as his father.
And she denies those allegations, Your Honor.
Understood, but the allegation is that then the police were called back twice after she was informed of that, and that there were threats, which, as Ms. Reiser's indicating, have led to the stalking charge. I'm actually, given those allegations, surprised that her bond is set so low. Motion for bond reduction is denied.
Thank you, Your Honor. One more thing, Your Honor. I apologize. I was hopeful that Ms. Crittenden would be released and we could have an afternoon spot on the 31st. I do have a conflict in the morning.
You can talk about this. Well, it's going to be in the morning.
Right. No,
Put it on the 7th.
That's what I'm asking for, Your Honor.
All right. Probable cause conference, August 7th, 2025, 9 a.m. Bond will continue. Motion for bond reduction having been done.
Thank you, Your Honor.
What are we doing? Sir, Mr. Dick, he's still muted.
Yeah.
Why is he brought up? Oh, there he is. Sir, can you state your name, please?
Ibrahim Jakaite.
Okay. What are we doing?
In the matters that I represent, Mr. Diakete on 1232 and 1233, we will be requesting a set for a preliminary exam. To my knowledge, all discovery is complete in both of those cases.
Same with 5153.
You want an exam set?
Yes, Your Honor. I did meet with him last night.
Now the courtroom pivots into a completely different defendant, but the theme stays the same: bond, risk, and whether the court believes supervision can actually protect the public. This time, the defense is trying to present Ibrahim Jak as someone with structure, employment opportunities, transportation, family ties, and no reason to contact the complaining witness. That's classic bond mitigation strategy. The attorney is stacking stability factors one by one, hoping the judge sees somebody manageable on tether instead of somebody dangerous in custody. But here's where experienced courtroom watchers immediately tense up. Prosecutors love waiting until after those polished defense arguments before unloading the incident details. And once that response begins, the energy in the room changes completely. Suddenly, we're not just talking about tether requests anymore. We're talking threats toward officers, high-speed pursuits, a stolen motorcycle, alleged violence involving a dating partner, and prior convictions. The defense tried to frame this as rehabilitation and structure. The prosecution is about to frame it as escalating chaos across multiple separate incidents. And when judges hear multiple cases stacked together instead of one isolated event, it creates a cumulative effect that becomes extremely hard to overcome in bond discussions. You can already sense this hearing drifting toward another denial before the prosecutor even finishes his speaking.
So keep an eye on.
People have their witnesses available the 29th.
We'll do our best, Your Honor.
Preliminary examination will be set in person July 29th, 2025, 9 a.m. before Judge Washington.
And Your Honor, when appropriate, my client would like me to address bond.
Go ahead.
Yes, Your Honor. Mr. Diakate would like me to request a release on tether. He does not reside at the same location as the complaining witness in the 1232 case. Prior to incarceration, he began working full-time as a caregiver. He'd like to be able to return to that work. He does not have to be, he has no reason to be in contact with the alleged complaining witness in this case. No children in common, no residents in common. He does have his own transportation and will be able to return to court. He does have ties to the state of Michigan as he has family who resides within the state in different cities. So he'll be requesting a tether with a release on tether, personal reconnaissance bond for release on tether in his cases.
Your Honor, just two things on my case. I'm trying to figure out what the bond is. Does your record show what the bond is on the 23 case?
The 23 case bond is $1,000. 10%.
All right, thank you, Judge. I would just echo that, Judge, request for bond. And again, this is a 23 case that happened in the jail.
Response?
Your Honor, I would object to any modification of bond. This defendant is looking at 3 cases here, and I'll go through each one by one. In his R&O case, he is an officer tried to stop the fight and told the officer that he was going to kill him when he got out of jail. At his next case, he was throwing rocks at someone's windows. Officers arrived, saw a motorcycle leaving, confirmed it was the defendant, and a pursuit began where he reached speeds of over 100 miles per hour in a 45-mile-per-hour posted zone. He was caught after the motorcycle had stalled, and the motorcycle turned out to be stolen. And then in his third case, him and the victim, who were working together, had a dating relationship. An employee at that restaurant called 911 to report that the victim had been dragged from the women's restroom, kicking and screaming, to a car. And the colleagues at work had saw visible scratches on her face. And after being put in the car, the defendant then drove away, and the victim jumped from the car, and officers found her in the middle of the roadway. I also want to know.
That prosecution summary was absolutely devastating from a bond perspective. Look at how the state structured it. They didn't just list charges, they built a progression of danger. Threats toward an officer, a pursuit allegedly exceeding 100 miles per hour, a stolen motorcycle. Then an emotionally explosive domestic violence allegation ending with a woman jumping from a moving vehicle into a roadway. Prosecutors know exactly what they're doing when they present facts in escalating sequence like that. And then comes the final punch, prior convictions and another active hold from a different county. That matters because courts evaluate not just the current allegations, but the defendant's overall pattern of behavior and compliance history. By the time the prosecutor finishes, the defense's tether request almost feels disconnected from the severity of the allegations now sitting in front of Judge Simpson. What stands out here is how quickly bond hearings become credibility battles. The defense talks about stability and employment. The prosecution talks about risk, fear, violence, and public safety. Judges then have to decide which future scenario seems more believable. And honestly, once the phrase 100 miles per hour in a 45 enters the hearing, combined with threats and multiple pending matters, the courtroom momentum shifts hard.
That he has a previous DD conviction from 2023, and he currently has a hold from Delta County with bond denied. So I would be asking that bond remain as set in this case, Your Honor.
Anything else?
No, yeah.
All right.
Nothing from me. Nothing
Given
from me.
all of those circumstances, motion for bond reduction is denied. Bond will continue in all 3 matters.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case.
And good afternoon, Laura Yagi, Assistant Public Defender, with on behalf of Ms. Hill. Your Honor, I do have a green sheet. I apologize. I am seeking an adjournment for further discussions regarding the case.
And no objection, I did want to address bond.
Probable cause conference, August 7, 2025, 9 a.m. Yes, that's the bond.
Simply wanted to request, there is no testing order whatsoever on this file. I provided the court, you may have the hard copy of Ms. Hill's. I think it started with trouble and she may now be on scramble, vice versa in her circuit court case. I just wanted to ask that we have an order here to accompany that so that we get those results, because currently they're only being sent to 27.
Oh, you guys don't get them. I get them because of our game, but I got you. You're on a scram now. Right. When did you go on a scram?
They put it on me before I got out of jail, July 8th or 9th.
All right. What I will do is I'll continue the defendant's bond, and we'll order a scram tether on this case. We don't have to put another one on her.
Thank God, we're out of space.
What do you say?
We're out of space.
Got 2 left.
This section is fascinating because the mood suddenly changes from intense bond arguments into something awkwardly human and procedural. After all the serious allegations earlier, the courtroom briefly turns into a discussion about scram tether logistics, paperwork confusion, and even literal equipment space. That tiny "thank God we're out of space" joke from Judge Simpson cuts through the tension for a second and reminds you how chaotic, busy criminal dockets can become behind the scenes. But beneath the lighter moment is still a very important issue: monitoring compliance. The defense wants confirmation that testing and tether conditions are coordinated correctly across cases so records don't fall through the cracks. That sounds administrative, but in criminal court, administrative gaps can become major problems. If testing results are not shared properly, violations may go unnoticed or defendants may end up accused unfairly because agencies are not communicating clearly. Then the hearing shifts again into the civil standby issue, and honestly, this exchange perfectly captures courtroom frustration. The defendant says police told her a judge had to order assistance so she could retrieve belongings, while the court seems confused why officers refused without written authorization. These moments matter because real life doesn't pause while cases move through the system. Housing issues, property access, and restrictions all collide with bond conditions in messy ways.
So we can put one on each line. They've done that before.
Your Honor, I'm so sorry. I'm just asking for civil standby. I think it was an oversight at arraignment, but we just need a civil standby for her to get her belongings.
To do what?
For her to get her belongings from her residence. She's been evicted, but it is the location that she's not allowed to go back to. But she was told that she could get her belongings with a civil standby. And for some reason,
I don't need to order a civil standby. You called me.
They wouldn't come out when I tried to do that. I said I had to be ordered by a judge. I'm not allowed on the property.
So I don't know if
Sheriff's Department told you that?
Yes.
If I scream loud enough, is that an order? Really? I've never. Ms. Yagi, craft an order.
Okay.
That's not how that works.
I was going to say, I'm happy to just send them JIS if the court just indicates like, okay for
Do an
civil.
order. They want an order?
Understood.
Do an order.
Got it.
People out of room, I'll put a big signature on it.
Thank you, Your Honor.
All right. Thank you.
Roba Handon. I am here with and on behalf of Justin Hodge. Can you please say your name for the record?
Justin Paul Hodge.
Thank you.
Your Honor, we would like to set preliminary examination at this time, to
All right. Is all discovery complete?
the best of my knowledge.
All right. People have their witnesses available the 29th.
Try our best.
Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Barr.
And then when appropriate, we would like to address bond as well.
Of course you will. Go ahead.
Your Honor, my client is asking for contact with his 2 children to be reinstated. He advises that he would not need to be in contact with the claiming witness in order to do so.
Response.
Your Honor, we would object to any modification of bond. The defendant was on probation when this case occurred for another domestic violence case in Wayne County. He's currently being held out of Wayne for that. He currently has a hold out of Wayne for that DV with bond being set at $1,570. And this current case involves the defendant having an argument with his girlfriend, taking her phone and smashing it, and his admitted to throwing the phone. So at this point, we believe bond is set as appropriate.
Were the children there at the time?
They were.
They were present at the time of
The 2-year-old was present.
the 2-year-old. So one of the children was there. Any other comments?
No, Your Honor.
All right. Motion for bond modification is denied at this time. Bond will continue with the conditions. Thank you.
And the hearing closes with yet another defendant trying to modify bond conditions, this time specifically asking for contact with children to be reinstated. The defense carefully argues that communication with the children could happen without contact with the complaining witness, which is an important distinction legally. But prosecutors immediately counter with prior domestic violence history, active probation issues, another hold from Wayne County, and allegations involving the destruction of the victim's phone during an argument. Then Judge Simpson asks the key question, were the children there? That single question changes the emotional weight of the hearing instantly. Once the court hears that one of the children was present during the alleged incident, the possibility of bond modification becomes dramatically less likely. Judges take exposure of children to domestic conflict extremely seriously, even when the children are not direct victims. Across this entire docket, one theme kept repeating itself. Bond decisions are not just about charges. They're about behavior patterns, compliance, escalation, prior history, and whether the court believes future restrictions will actually be followed. Judge Simpson consistently leaned toward caution, denying reductions when allegations suggested repeated violations, public safety concerns, or instability. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.